Welcome to HR Voices, a podcast for independent HR and people professionals and the businesses they support. HR Voices is brought to you by the expert team at HR Independence Limited. We hope you enjoy.
Hello, everyone. Welcome to another edition of HR Voices podcast. I'm your host, Mary Asante. And with me here today, I've got the amazing Scott Walker. Hi, Scott.
Hi, Mary. Oh, thank you for that lovely introduction.
Thank you for joining me today. And I'm really looking forward to our conversation today. And our regular viewers and listeners would notice that I don't have my partner in crime, Charlotte Alfrey, with me here today. She's just out of the office today. So, Scott, welcome once again to HR Voices podcast. And as I said, really looking forward to this conversation because you are one of the few people that I've listened to talk about Wills and Probate and made the whole conversation around death sound less mysterious and less scary, so to speak. So, yeah, looking forward to it.
Oh, thank you. That's very kind and great to be here. Looking forward to the conversation and thank you so much for inviting me on.
Excellent. Thank you for coming along, Scott. And today we are going to be talking about how HR consultants, and for that matter, any consultant or any individual running their own business or small business or self-employed, really, may benefit from having a will in place and what benefits there will be from a business perspective as well. So, Scott, for the purposes of everyone listening to us today, what really is a will?
Great question to start. A will is a way of ensuring that we pass on our assets. So our property, if we own property, whatever money we have, our business, if we have a business, it might even be our personal possessions, whatever we own. So it's ensuring we pass everything we own really to the important people in our life. So loved ones, relatives, our partners, our children, and we're ensuring it passes to them when we pass away. And that's the fundamentals to a will. And there are lots of other things kind of part of that, but it's just making sure that we do have a say really in what happens when we do pass away, because it's something we all have in common. Unfortunately, one day we will all pass away.
Yeah, thank you for that introduction, Scott. And also thinking about it, yes, inevitably we would all get there one day. And why is it important that we even contemplate having a will? Why is it important to have a will?
There are lots of important reasons that there really are. I always start by saying it's a way of protecting our assets, as I mentioned a moment ago, but also protecting our loved ones and also protecting our business as well. So again, if we have a business, and even if we are a self-employed consultant or have our own business, again, it's a way of protecting that as, you know, as an asset, but also what's going to happen when we pass away. And that there are lots of other reasons why it's important. And I touched upon a moment ago, making sure, you know, we can pass on everything to our loved ones or whoever it may be when we do die. But also it's a planning exercise as well. So we're able to plan for the future. And by that, I mean, it's not always just about death. So when we make a will, that we often think, it is only about when we pass away. And surprisingly, I've noticed over the years working with clients that everybody will have a will. Everybody will have a reason why they want to make a will.
Yeah.
And that will be an important thing to them. I often say that it's their why, why they want to make a will. And there will be a reason. Everybody will have that reason. And it's often not just about what happens when we do die. It could be that we want to make sure our children have the best possible financial security. It might be that we've entered a new relationship. It might be that we are going through a divorce or a relationship breakdown. It might be that we want to think about what's going to happen in later life. So again, going back to the planning point, it's thinking about, what do I want if I need to go into care in the future? What will that look like to me? And it might be that we have almost conflicting issues, if you like, going on. So we may want to ensure that if we are married or in a civil partnership, or if we have a partner, we want to make sure they are provided for. But we then may have children to consider as well, or even other relatives. So if we don't have children, we may have other important people in our lives that we want to benefit from our assets when we pass away. So there's all these things that are feeding in. And as I say, often it's what we're thinking about during our lifetime. It's life events that is then drawing us to actually go out and make that will.
I mean, that's actually quite interesting to look at it from the point of view of not just thinking of passing on, but also generally a way of thinking about how you would want to either protect your assets, redistribute your assets, or who you'd want to entrust with your assets when the time comes, for whatever reason that you might be doing it. And actually, then that leads me to really ponder what happens if someone doesn't have a will.
Yes, goodness, another great question. So there's again, there are lots of things, in all honesty, that can happen. There are perhaps two main things to think about. One is that so the law decides, really. So, if we don't have a will or we haven't got a valid will, then we have a set order. So the law says, well, this is what will happen to my assets. So my assets will go to these family members. So the choice is taken away from us. So we haven't then got that security, that peace of mind that the people that we want to benefit and we want to pass on our assets, our wealth to, they may be excluded. And, in some situations, the order that the law sets out who will inherit, where we don't have a will, can be quite difficult because it's not what we want. A really good example is if we're not married or in a civil partnership. So partners and, long-term partners, if we've been living together for a long time, we don't have a will, they won't benefit from any of our assets because the law doesn't recognize a cohabiting couple, couples who are living together.
That's interesting because I thought that had changed.
No, unfortunately not. Unfortunately not. It has been talked about a lot, and there's been a lot of talk within the profession and within committees who are considering law reform and providing feedback into these areas, and they are very much in favor of cohabitants and couples living together being able to benefit from the legal rules. We call them, in case I say this again and I've not explained, we call them the intestacy rules. So when I say the legal rules, what happens when we don't have a will, they're called the intestacy rules.
Right.
But there's also equally, there is a school of thought which thinks that cohabiting couples perhaps shouldn't be part of that because they haven't, dare I say, they haven't formalized their relationship by way of marriage or civil partnership. So, there are very different opinions on that.
Yeah. Okay, thank you for clarifying that bit. And when it comes to how HR consultants or self-employed consultants or even small business owners might benefit from a will, how might we benefit from having a will in place?
I think when it comes to, having a business or, say even being self-employed, the benefits are, again, it's going back to what I was saying earlier about planning. It's making sure that there is a plan in place if something was to happen. So unfortunately, we don't know when it's going to happen to us. We don't know when we're going to pass away. We all hope we will live to a great age, but unfortunately, the unexpected can happen. So this is having the will is then the opportunity to say, okay, so if something does happen to me, I want my business to continue running. And I have said within the will, these are the people, these are the relatives or my business partners. These are the people I want to take over and have my business. So that's one aspect to it. And there's also the point about when you make a will, you're appointing what we call executors, so people who are going to manage your estate, who are going to manage everything when you pass away. And you want to, again, have a choice of executors. And if there is a business involved, then it's a great idea to have people who know your business and who will be able to take over some of the running of it whilst the will is being and your estate is being sorted out. And you listeners have probably heard of the probate process, and often when we die, we will go through, particularly if we have a will, we'll go through this probate process. So there is a time when things will need to be dealt with. So having that choice of executor is really important, so that the business can continue. The other aspect to it is depending on the business you've got. So if you're a sole trader and self-employed, it's a little bit more straightforward in the fact that, if you have business assets, you can say that you want a particular person to benefit from those assets. And equally with a partnership, you may have something within the partnership agreement which sets out what's going to happen if a partner dies. But again, within the will, you want to make sure that any business assets pass to whoever you want to, or you might want to think about the business continuing. So what do you need to pass over to your business partner if it is a partnership? If it's a company, a limited company, it's important to check your company formation documents, your articles, and see how the business is structured and what provision are in the articles for when you pass away. So, for example, the existing shareholders may have rights to your shares. So if it was me passing away, then there may be a mechanism in place to say, okay, as I say, the existing shareholders can then buy or have the opportunity to buy my shares to make sure the business can continue, or there are not outside influences coming in.
Yeah.
So it again, it is that planning point, and it's a good opportunity also to, review your business structures and also see, what else I might need to do,
Hmm.
either within the business, but also connected with what's going to happen when I pass away. So you're almost doing two jobs in one to a
Yeah.
certain extent. So, but it is just having that insight into, what do you really want to happen to the business? Who do you want to look after it? Who do you want the assets to go to? Is it going to continue as a going concern? And then putting in place the the planning options, if you like, surrounding that. So you've got some certainty.
Great. So in terms of from a business point of view, then what happens if an individual, I'm guessing for individuals who are either self-employed and so traders will be straightforward because whichever account that the money will be sitting in is a personal account anyway. So probably can be treated and may be treated in the same way as any other personal asset according to their will, even if the business is not specifically mentioned in it. But where I think complication may set in might be where you've got limited partnerships or limited companies, etc. What happens if you've got or you are in or part of one of those and you pass on without a will, or your will doesn't mention or address your business at all?
Yeah. So again, it's what will happen if there isn't a will. The first step, so if it is a company, it's checking, and to an extent a partnership, it's checking what the partnership agreement says, what's going to happen if one of the partners passes away, and also the company to the articles, your company formation documents. So because sometimes there will be provision within there which states what is going to happen. But the difficulty is we are then still in terms, so let's just say, in terms of if you own shares in a company, as an example, then if you haven't got a will, then you're then back to the intestacy rules I was talking about earlier. So the rules that we have, which then say these are the people who are going to benefit from your assets because you haven't got a will or your will is invalid. So you've then got this situation.
Of interest, if I can just jump in here, Scott.
Yeah,
How
cool.
does the intestacy rule work? How does the law determine who gets what? If let's consider a scenario where you have a family, so you've got a partner and kids or whatever, and maybe another scenario where you don't have a civil or legal partner, or any children at all. So what happens in those two scenarios?
Yeah, so let's just say we have a spouse or civil partner and children. So a portion of your estate will go to your spouse or civil partner. So it sets out, it's actually a particular amount. So there's a sum, we call it a statutory legacy.
Okay.
There's a sum of money which will go to a spouse or civil partner. And then if there is assets or the total amount of the estate is then above that amount that's going to the spouse or civil partner, the rest is then split between, so half to the children and then half again to the spouse or civil partner. So you've got this situation where it depends on, how much money you've got, effectively, how many assets have you got, which then determines how much is going to go to your spouse and civil partner, and then part of it will go to your children. So you can see the difficulties there because again, it's your.
So if it's below the threshold, do I assume that automatically then goes to your spouse or partner? Right.
Absolutely, yeah, that's right. So it would, if you're below the threshold, it would go to the spouse and civil partner. So at the moment, I think I'm right in saying it's 322,000. So it's a considerable sum of money. But if you've got a property, for example, which is quite valuable, then you could easily exceed that amount. And equally, if you have a business, you know, depending on the value of that, you could exceed the amount. And then that's where the complications can arise, because you've got this situation where children may be inheriting part of the estate. There may be young children, which adds more complexity to it. But then if we have, so for the other scenario, if we're not married, so we're living together as partners, but we have children, then your estate will go all to the children.
Right.
So it's, as I was saying earlier, unfortunately, if we're not married or in a civil partnership, our spouse or civil partner are not entitled. So again, it can cause complications if you've got, you know, assets going to young children, for example, or you know, potentially a large sum of money going to children. You may have wanted your partner to benefit because you want to give them some security. I would just add as well, it does depend. So when we are dealing with the intestacy rules, it does depend on how you own your assets. So common example is a property. So if we own our home jointly, and even if we're not married or in a civil partnership, we may own a property together as partners. But if we own it in a certain way jointly, then there is another legal rule which says the property automatically goes to the surviving owner. So I would just add that it's another kind of aspect to it, and it's important to check how you own. If you own it jointly, how do you own the property? Because that will then say, you know, and dictate what's going to happen when you pass away. So another added element to it.
Right. It never gets simple with the law. There's always an added layer of complexity for you to look at and to consider. So what happens if you own a business and you don't have a spouse, you don't have any children, and how does that then play out as well if you pass away without a will?
Yeah, so that's when we start introducing other relatives to the mix. So again, it goes in an order. So there's a strict order of relatives who can then benefit from your estate. So it would be parents, if they're still alive. It would be brothers and sisters. It would be nieces and nephews if your brothers and sisters have passed away before you. And then grandparents are in there as well, and then uncles and aunts, and potentially cousins if uncle and aunts have passed away before. So there is this set order, and it's usually another relative. And you know, in some situations that might be okay, but you know, you can imagine if you've got a large family, you may want different relatives to inherit from you. You may want to pass particular items on to a certain niece or nephew. So again, it's almost that loss of control. There's no certainty in what's going to happen. You know, it will go to somebody, but you don't know who that will be, or I should say, or you do know who that will be, but you don't know whether that's going to be right for your situation. So it's you know, it's more complexity. And then ultimately, if we don't have relatives, it does go to the state, to the government. So again, you know, that might not be what we want. I often have clients who like to leave their money to charity, for example.
Yeah, I think the points from what that I'm gathering from this conversation is the importance of why. I mean, why it's absolutely beneficial to have a will in place in the first instance, because in the very least, it ensures that your assets go to people that you would like to go to, rather than leaving it to the law and the state to decide how it's invariably split up. Or again, touching on the limited company aspect of it again, where you have a limited company. So let's say I've got Mary Asante Consultancy, for example, which I'm the sole shareholder, and something happens and it's not stated in my will at all, then what happens? But we've covered that. Where again, you're involved in some partnerships. So if I take myself again through HR Independence, HRI is a limited company by shares, and there are few shareholders involved in that as well. So if you think about that, and according to the articles of association, maybe your agreements, your shareholder agreement, etc., you have in place, may determine what happens if one particular shareholder passes on in that instance. So if, let's say, I wanted to incorporate both organizations and any other shareholdings I may hold into my will, do I need a separate will to my personal assets? Because this is a limited company and technically it's a separate entity to myself, or can I just incorporate it into my personal will, as in that just caters for my personal assets? I hope I'm making sense.
Absolutely. No, that's perfect sense. No, that's, yeah, perfect. So you can actually have one will. So the will incorporate and can incorporate all of your assets. So whether that's personal or business assets. What you might want to think about from a business perspective is you may want to have a trust in the will, which is setting out what's going to happen to the business assets. So that may be separate, but it will still be within your will. The other thing as well is when it comes to business assets, so if your estate is liable to inheritance tax, on some business assets, you can get relief from inheritance tax.
Right.
So again, it's another benefit of having a will, because it will give you that opportunity to plan for inheritance tax, seeing if you're likely to have a liability, and also thinking about, okay, so I've got these, if your estate is large enough to attract inheritance tax, you can then consider, I've got my business assets, I need to make sure that I can qualify for the inheritance tax relief for the business assets. So that's another aspect. So it may be, as I say, you may have a separate trust, but you will also want to consider a letter of wishes. So a letter of wishes is a separate document to the will, and you can set out, to be honest, anything you want to. It is an informal document. They're often used where there is a trust in your will, for example. So if you are going to incorporate a trust for whatever reason, whether that's business assets, as I've just mentioned, or it might be, further tax planning or just protecting some of your assets, you can then have this informal document, this letter of wishes, which sets out what your wishes are for the trust. So again, it's really useful, and that is a separate document. And I often recommend doing one for everybody making a will, because it's a good way of exploring the wider things of making a will. It might be funeral wishes, as an example. It could be how those personal possessions are going to be distributed. So you might have, jewelry, for example. You might have a collection of something that you want certain people to have. So it's a good way of putting in all those informal detail, if you like, which builds upon the will. And really important if there are business assets, because it's an opportunity to, almost have your say and give some guidance to your executors and trustees who are going to be managing all this when you've passed away. So they're going to need, some pointers.
Yeah, from you as to what you really want them to do on your behalf in their capacity as executors.
Absolutely. It really, I think, executors is again, it's a really important point. And another reason, another benefit to having a will, because you will choose the most suitable executors who may then also be trustees, but they play such an important role. It's, choosing, as I mentioned a moment ago, choosing the right people, really, and people who will get on, people who know your situation, and have some experience of acting in that role. It's quite a responsibility.
It absolutely is, yes. Again, I've got a follow-on question from that, Scott, which is, I know some people sometimes have joint wills, and if you've got a joint will and the business aspect is just one of you, so let's say the shareholder is you, not your spouse or your partner, how best would you sort of advise that people go about that?
Another great question. So joint wills, they are a funny one. So you can have joint wills. You don't see them so much nowadays in practice, and you would if you do come across them nowadays, then they would be called, again, I'm getting a little bit technical now, so apologies, but I'll explain the best I can. But so you often see them as what we call mutual wills. But a mutual will is slightly different in the fact that you do still have two separate wills, but there's a binding contract. So, and that's when it does really get complicated. So you'll then get into the realms of trusts and a little bit of contract law. So, and then the other form of joint wills we see nowadays, we often call them mirror wills, but they are separate wills still, but it's just that they are very similar in the terms. So usually a couple would make a mirror will and they would want similar things. So usually they'll pass everything to each other and then it might go on to children or other relatives. So, but again, as I say, you do have separate wills for that. So it can be tricky with the joint wills.
What I was asking is a follow-on question from whether for when you have your will, your business aspects should be a separate will to your individual will. And you address that by saying, no, actually, you can just have a single will that addresses all of it. And the question was, so what do you do in situations where you may have a couple, for example, having a joint will or a mirror will, as you just explained, but one of them is a shareholder of a business or a business owner? Is it advisable for them to bring that into that mirror will or the joint will, or should they treat it as their will or wish letter as a separate entity to that, is what I was trying to get your view on.
Oh, that makes sense. So thank you for that. That helps. So yeah. So again, yes, another great point. So it's you would still have your own will, if you like. So whatever you decide to do, you will always just have the one will, which is going to then cover your personal and business assets. You then may have the letter of wishes alongside it, which I was talking about earlier. But if it's part of a couple, so usually we wouldn't make a joint will as such nowadays. You would never recommend them to anybody now. There are certain situations where you may have, as I was saying earlier, this mutual will, but very rare and probably not in a business situation. So it would be the things to think about are, if you are a part of a couple and one spouse or civil partner, they have their business assets or shares or whatever it may be, they just then need to think about, okay, so who do I want those shares to go to if it's not going to be my spouse or civil partner? But the other thing to think about is, okay, do I need to be doing this as a separate person, i.e., that you're going to a solicitor and by yourself and just doing your own will as opposed to doing it as part of a couple. And the reason I say this is because there could be some conflict there between between what the spouse or civil partners, what they want. If you have got separate assets, perhaps, you're completely financially independent, you're probably at least going to want to think about doing it on your own. You are going to obviously think about, well, what do I need to give my spouse or civil partner in my will? How is that going to work? So it's more a case of just thinking through your own situation and working out, what do I need to provide to a spouse or civil partner? What do I need to do with my business assets, my shares? How can I make this as easy as possible? But also, just making sure it's right for what you want. There is very much a practical side to this in terms of, as we were talking about earlier, making sure the business can continue to run and, what's going to happen to shares if it's a limited company. But there's also the kind of almost emotional part to it where you're thinking about, well, actually, what do I want? Who do I want to benefit from, from my assets and from my money or business or whatever it may be.
Excellent. Thank you so much, Scott. Again, as I said, it was going to be an amazing discussion, and I think it's been wonderful. We've covered quite a lot, and thank you for explaining so that we can all understand what it means to have a will, how important it is to have a will, and why everyone should have one, especially if you are a business owner, if you are a consultant, or if you're a shareholder in any capacity. So thank you. It's been extremely helpful. We like ending our podcast with top tips from our guest. So what would your top 3 tips be?
My top 3 tips would be, first one would be, and it's something I was talking earlier about, have a think about why you want to make a will. And as I say that, it may sound a bit obvious, but I think we will know the reasons, the benefits of having a will, but it's just uncovering what's important to us. It kind of linked to what I was saying a moment ago, is making sure that the will does what we want to do. So take a bit of time, and I think what happens when we do start the process of making a will, and I often see this in clients, we kind of approach it a bit like, it's quite isolated, but there is a lot going on. So taking a bit of time just to think it through, just to plan and have a think about what assets you have, and do a family tree, because that will help work out who's going to be part of your will. So that would be number 1. Number 2 would be, have conversations about passing away and illness. Because often I think we find, certainly within the UK, we're a society which perhaps shies away from talking about dying. I see this in my own kind of story with the work I do in Wills and Probate, but also making my own will. And the fact that we don't talk about it, and we don't spend a bit of time just reflecting on, well, unfortunately one day, we will pass away. But if we can start to talk about it, it helps us to live well and makes us think about important things in life. So it's not all about, the sad stuff. So that would be number 2. And then number 3 would be, think about making a lasting power of attorney as well. So wills will deal with what happens when we pass away. Lasting powers of attorney sets out who can help us and make decisions for us if we become ill. And lasting powers of attorney just as important as a will, particularly in a business context, because it's that planning piece around, well, if I get ill, I want people to be able to continue to run my business for me. So that would be the third tip.
Great. Thank you for those fantastic top 3 tips. Very helpful. And once again, thank you for coming on the show today and for sharing your incredible experience around wills and probate.
Oh, thank you so much, Mary. It's been a joy to be on the podcast. It really has. And yeah, what a great conversation. So thank you once again for inviting me on.
Great. Right. Thank you very much for tuning in and for listening to us, or if you're watching us, for watching us today. Would love to hear from you. So you can get in touch with us at hrvoices@hrindependent.co.uk with any questions that you may have on the topic that we've discussed today, or any topic that we've discussed on any of our episodes. Or if you'd like us to talk about particular subjects, do get in touch. But thank you for tuning in, and see you again soon.
We hope you enjoyed this episode of HR Voices. If you have a topic you'd like us to cover or would like to be a guest, we'd love to hear from you. Connect with us on social media or email us at hrvoices@hrindependence.co.uk. Tune in next time.